Schubert, take your time. Take your time.
Good morning. May it please the Court. Attorney Greg Schubert for Joseph Druce. As the Court's well aware, Mr. Druce is engaged presently in some conduct such that he would prefer that I not be arguing this matter before the Court this morning. As a result of that, I wish to point out that the one thing that Mr. Druce has asked me to give this Court in this argument is as follows. He requests that while I may, in my brief, have requested some relief under 278-33E, he does not, under any circumstances, want any such relief that would suggest in any way, fashion, shape, or form that he is suffering from a mental defect, and that he would reject and would hope that this Court would not in any way give any relief based upon anything that would determine that he would have a mental defect.
Mr. Schubert, would it be fair to me to conclude from what you have just said that this is in the nature of an argument similar to a Moffat, as if he had submitted a Moffat brief?
I suppose, Your Honor. I guess
Okay.
It is clear to me that the defense at trial obviously wasn't accepted by the jury, but in my 30-some years before this Court, I know you're not concerned with observations of counsel, but Mr. Druce is not on the same page as the rest of us. I would go on to say that this case clearly is somewhat summed up by the fact of the old nursery rhyme that all the king's horses and all the king's men can't. And I think we know what the rest of that is. And the argument that I'd like to make just briefly is that there are two things that might come out of this case that would be good. The first is, I draw the Court's attention to the appendix and Justice Hillman's decision on the motion to dismiss. And I believe that there's only one way that you can read that. The conduct of the government and the agencies involved here were clearly egregious.
We're talking about the Department of Corrections at this point.
That is correct. And all of the things there, too. I mean, releasing of stories by unions, guards, it's a very bad ball of wax. And clearly...
Well, isn't the worst problem from the government's point of view that the DOC prevented him from having contact with his attorney without overhearing the conversations?
I would suggest to you that that exists even until today.
Well, let's take a step back here. We've got Mr. Druce, who is found in the cell of former priest, Father Gagan, clearly murdered him.
There's no doubt about that.
No
he
doubt
announced
about
that
it.
at least 6 or 7 times during the trial.
He's announced it, and the evidence couldn't be
Absolutely.
clearer on that.
Yeah, actually, we have a tape that pretty well is very conclusive.
And he files a motion to dismiss his file because of claims that he's been harassed and his right to counsel has been interfered with in a number of ways. Judge Hillman, is it not?
Yes, it is.
Ruled on the motion in a, I don't know, about a 10-page or so.
It's 172 in the appendix.
11-page. And what I found curious about this is that the judge, first of all, let me understand, was there an evidentiary hearing at which Mr. Druce testified to what he felt was going on and why he was being, or what the Department of Corrections officers were doing?
I believe that they were submitted by affidavits, not an actual hearing.
So you don't think there was no evidentiary hearing?
To the best of my knowledge, that is correct, Your Honor.
I find the judge's sort of handling of this interesting. On the one hand, he says that there's no evidence to support the allegation that the conversations between Mr. Druce and his attorney were monitored. So he makes a finding there that there is no evidence that those conversations were secretly overheard by the Department of Corrections. I think we have to accept that. I think. And then with respect to so many of the other allegations, the judge seems to be saying, I'm not making any findings, but there certainly are substantial allegations, and if they can be supported, They might be the basis for a civil suit. But I don't see that, essentially, I don't see that even if they're true, there was any prejudice here, that the relationship between Mr. Druce and his counsel was not so disrupted that he couldn't get an adequate defense, and that he got an adequate, or that this was a pretrial motion, and that he could prepare for trial. Isn't that sort of what the judge is saying? He's not making findings that all this bad stuff happened. He's saying, I'm going to sort of assume that it happened, and if it did, it still is insufficient for me to dismiss this case.
Quite honestly, Your Honor, I believe that what he's saying in this decision is as follows, that under King and Lewin-type situations, that he did not have faith that if he had made a decision to dismiss this case, that that decision would have survived based upon the facts that were accompanying this case.
Sorry, say that
That's
again.
the way I believe that he was saying, and I believe that Judge Hillman, in his language, because it is certain that my characterization is egregious conduct. I think he accepts that. I think that's clear from his writings.
He accepts the fact that the allegations are of egregious conduct. That's what I'm getting to. He says here, accordingly, the alleged misconduct by prison officials, the alleged misconduct is egregious. This is egregious, but he doesn't make findings that these things actually happened.
I agree. And the problem becomes is that I believe that from a fair reading of his decision, you can draw the conclusion that a trial judge arrived at a conclusion that should he actually find the facts that would have supported a dismissal, and a dismissal would have been issued, that it would not have survived appellate review. I believe that's a fair interpretation of Justice Hillman's decision.
Mr. Schubert, that may well be a fair interpretation, but in a sense, the one thing in our system that we ask trial judges to do is to make findings of fact. So he can make findings of fact. He may dismiss the indictment. He may not be held up. He may not be affirmed on appeal. And there's nothing that you can do about this. It's just that it's, as Justice Cordy points out, it's very difficult for an appellate court to conclude that the facts were established.
And I don't argue that.
Okay.
I'm merely trying to offer what I believe that actually Justice Hillman was trying to say when he wrote that decision.
Do you think, just taking what you and Justice Cordy have sort of characterized this decision, do you think that what it is asking, therefore, is assuming these facts to be true, or is your argument on appeal, assuming these facts to be true, you would say that warrants dismissal because of the egregiousness, and that's what we have to decide?
Yes, it seems that, I think that is the argument of my brief, that at some point in time, both trial judges, defense lawyers, and prosecutors need some kind of bright line where they know that there will be conduct for which there is a prophylactic measure that will be a dismissal because it will not be tolerated. It seems that we have stepped back from excluding certain things.
Let's go through that conduct then. Setting aside, because I think the judge sufficiently ruled out that the conversations between the defendant and his lawyer were overheard, monitored. Leaving that aside, what is the conduct here that we should assume was established?
I think that you can believe that there was false tapes, false statements all tendered to the defense in this particular case. There were stories leaked by individuals that were part of agencies of the Commonwealth to the
Commonwealth
press.
leaked information about the case.
And it's very clear that that would have affected the jury pool.
I mean, there are ways to remedy that, and the judge said we can remedy the prejudice that might accrue to the jury pool.
And Judge, we have to admit that no matter how prejudiced the jury pool would have been, the defendant undoubtedly was still going to make 7 statements during the trial that he did in fact kill Father Gagan. That's an undeniable fact. It gets back to all the king's horses and all the king's men. And besides the fact that obviously the defendant in this case is serving another life crime sentence. The only thing that this court, at least in the opinion of counsel and on behalf of Mr. Druce, that I argue to you, the only thing that this court can do that will in any way give Mr. Druce any justice is to remove him from the auspices of the Massachusetts Department of Correction. Where he's incarcerated is probably the only question that's even viable in this particular case.
So if we do what you want us to do, where does he go?
If Mr. Druce was here, he would argue to you that he be incarcerated at an out-of-state facility in some other state. That's what he would argue to you. He has told me that on numerous occasions, Your Honor. That would be his wishes. That's what he would argue to you if he was arguing. Obviously, I don't know whether he could be placed in a house of correction setting because obviously we don't know whether or not there are facilities there. And regardless of what Mr. Druce believes relative to any 278-33E review, it's clear what the opinion of counsel that's making this argument is. I can't answer that for you. I'm sure that by an order of this court, it could be arranged that he be incarcerated in a situation that is not controlled by the Department of Correction. And again, I certainly am aware that this court does not concern itself with the observations of counsel, but Mr. Druce's situation is not much better today than it was back then prior to the trial, sir.
When he was serving the sentence, what sentence was he serving when he killed Father Gagan?
He was serving a life sentence.
For murder?
Yes.
I take it you're not suggesting, or are you suggesting that Mr. Druce would like to waive his motion to suppress? I take it you're not suggesting that. Because at least part of that is that he was too mentally ill to give a voluntary
What I'm suggesting to you
agreement
is that, at least from
waiver.
counsel's conduct, in moments of lucidity, I'm never really sure what Mr. Druce is suggesting to me is his true desires, other than the fact not to be under the auspices of the Department of Correction.
Should we remand this case to the trial court initially for a decision whether he's competent to waive counsel and whether he does wish to waive counsel, and then proceed on that basis? I mean, how do we treat the two different tacks that you and your client seem to be taking?
Well, as I understand my obligation is to argue for my client. My client does not want any 278-33E. He doesn't want it sent back. He does not believe that he has a mental illness or any mental defect.
I understand. I think Justice Cowan's point is an important one, which is typically we deal with competency to proceed to trial. But competency remains throughout, and the question is whether your client is presently competent to confer with you to reach a conclusion. I mean, I think that's what Justice Cowan is adverting to at the moment.
I would merely say that there are moments when that is true, and that there are certainly moments, at least in the opinion of counsel, and I'm certainly not trained, but that is not true.
Mr. Schubert, the request for relief that you have articulated this morning on behalf of your client, I just looked at, obviously, the blue brief deals with a separate set, but have you submitted that in some other piece of paper or document that I don't have?
I have not. This
Okay.
comes from conversations, and obviously as a
Sure.
result of some conversations that were had between myself and co-counsel with Mr. Druce in conversations this week
Sure.
pursuant to the actions that he's taken.
Okay.
Unless there's any further questions, I have nothing else to offer, and I submit on my brief.
Thank you, Mr. Schubert. Good morning, Ms. Lay.
Good morning. May it please the court, my name is Donna Marie Heron, and I'm representing the Commonwealth. I'm an Assistant District Attorney from the Worcester Division. First, I want to clarify something with the motion to dismiss. There was a 5-day evidentiary hearing conducted on that, in which the defendant did testify, along with officials from the Department of Corrections, and I think the defendant's paralegal fiance, girlfriend, also testified at this hearing. So there was numerous evidence taken. There was testimony by the defendant taken, in which the judge made his rulings based upon. And the judge,
But do you agree with me that he didn't make very many findings of fact?
Yes, he did. The findings of facts he did make was that the attorney-client relationship was impeded by having no contact visits, but that he said that did not require dismissal because it was reasonably related to peniological interests of the jail of keeping the lawyer safe, keeping the defendant safe, and keeping everyone else safe, particularly considering the defendant.
Okay, let's go through
sorry.
this. So the judge made a finding that in fact the department had restricted the contact between lawyer and client to non-contact visits.
Yes, that's through a glass
Through a
and
glass.
telephones.
Okay. Judge said yes, the department did that, but there were reasons,
But yes,
sufficient reasons to do that.
sufficient reasons for allowing that. And the same with the viewing of the videotape. He found that that was impeded the defendant's ability to view the videotape of him getting him getting extracted from the cell and being drugged up. But he also said that was also reasonably related, particularly to penal interest, particularly considering the defendant's after murdering a fellow inmate to swallowing objects such as pencils, a 10-inch cable cord, eye stem glassware. So he found that it was reasonably it was related to penal interest to allow to have the non-contact visits and have the way that they had the defendant view the videotape. He also found on the record that the Boston Herald article, the one with the defendant demonstrating,
Had been leaked by the
had been
department.
leaked by someone, and not anyone in the prosecution directly related to the prosecution, but some person in the Department of Corrections. But that he, and which did happen, was any prejudice resulted from this was sufficiently remedied by a jury voir dire, which comprehensively addressed any negative impact. And this did happen during the voir dire, was the jurors were asked exactly, what did you see, what did you read, what did you hear? And based upon that, can you still be a fair and impartial juror? And he asked every juror this. So any prejudice that might have resulted from that article, which I would like to say was released in August of 29th of 2005, which was at least 4 months prior to the trial. It was not released during the trial. It was released before the trial. The rest of the claims, he said, was he didn't make a ruling on. He didn't make a finding on. He said it could have happened, it couldn't have happened, but even if it did happen, it didn't rise to the level that irreparably prejudiced the defendant's ability to receive a fair trial, which is what this court bases its motions to dismiss on, based on King, Lewin, Drum, Gold, and all those cases. He found that the most troubling was the evidence or defense allegations that he was being threatened to plead guilty. And as you can see, this did not happen. The defendant did not succumb to these pressures, but instead had a 10-day full-blown trial, which he actively participated in. The rest of the defendant's claims didn't warrant discussion by the judge because it wasn't exactly fleshed out as to how these allegations deprived him of his ability to obtain a fair trial. So it's Commonwealth's conclusion that the Judge Hillman properly denied the defendant's motion to dismiss.
All right. How about the motion to suppress? These were statements made shortly after he was
Extracted
found
from
in
the cell.
Extracted from
He
the
was
cell.
brought up to the HS, the Health Service Unit. And
Explain to me this, first of all, when they finally got in the cell to get him out of there, he
After
said
10
something.
minutes. Yes.
He said something, right?
He makes, while they're trying to extract him, he's constantly making statements
About killing him.
about this had to be done, it's not against you guys.
And all of those statements were admitted at trial?
Yes.
Okay.
And then as the, I think it's at the time Sergeant, but it was Lieutenant Hammond, went to take his statement, the judge specifically found that the defendant was making spontaneous statements. And he said that there was no evidence that the defendant was subject to any questioning or any conduct designed to elicit a statement prior to the recitation of Miranda warnings given to the defendant.
And then he repeated in great detail
How
what
he
he
would
had
tell
done.
anyone or anything what he did. And that's where his statements
So the
came
question, of course, is whether he was mentally capable
of making
waiving such an important right.
And the judge found, based on, once again, the motion to suppress also had I think a 3 or 4 day evidentiary hearing on this as well, which testimony was taken. And based on the facts he chose to credit and based on the record, he found the defendant was, although clearly was mentally disturbed, that he nonetheless determined that he was capable of understanding the consequences of waiver, that he was sufficiently in control of his facilities, and that he was able to voluntarily waive his right and to make voluntary statements. And he based this on the fact that the defendant was coherent, that he was responsive, rational, was able to recall facts, that he was self-aware, aware of his surroundings, the people around them, and their supportive roles, and that he was not under any lengthy investigation or under any coercive pressures, and that he found that he voluntarily made much of the statements even before a question was asked to him. So the judge, where the judge's findings are supported by the testimony he chose to credit, and where he correctly applied the law, no relief is warranted in this case.
What do you say is to the present problem of whether the defendant wants to be represented by counsel or not?
It's a unique situation. I honestly would leave it up to the court's discretion to decide. I don't know the
But
proper
what other
avenue.
options do we have?
To be quite frank with the court, I do not know.
Well,
I mean,
Well, it's not, the relief, do you agree that in order to prosecute an appeal, a defendant has to be competent to do that?
I
That's a
would
legal-
believe so, yes.
I wonder, do you think that's so? Do you think
I
that's so?
think-
If he was competent at trial, and got a trial, or he was competent, found guilty, is there a question of competence with respect to appeal? If he then becomes incompetent, does that mean there can be no appeal? How would you deal with an incompetent person after trial? I wonder about that.
I do wonder. I am
Well,
not,
there's some-
I really can't give you an
There's
answer, and I'm
certain-
sorry about that, but
There are fundamental principles. One is that you're entitled to an appeal.
definitely,
Second,
yes.
you're entitled to have a lawyer. Third, that the attorney-client privilege rests on a meaningful communication between client and lawyer, and I don't know any case that says that that's out of the picture when you're up on appeal. Especially in unusual circumstances like this, where this is a conviction of murder in the first degree, and this court is statutorily authorized to entertain forms of relief which the defendant is saying he doesn't want.
Well, I would argue that the defendant cannot waive review under 33E. It's your statutory obligation to review the entire case.
Let
and
me
I
put
don't.
it this way, slightly differently.
Okay, I'm sorry.
We have had cases, not frequently, but they do occur, when a defendant who has been convicted of very serious crimes chooses to waive his right to further appellate review. We do not accept those submissions absent a full colloquy before a single justice of this court, or if it's in the appeals court. And one of the things that we inquire about is, and we look for, as you do when you're taking, in essence, any submission of a defendant like this, that, is it knowing, is it voluntary, is it, subject to coercion, so on and so forth. Essentially, it seems to me that what Mr. Druce has done in this case is to, in essence, ask his counsel to waive his right to prosecute an appeal. And so I suspect that, I don't know, but I think that, the suggestion of Justice Cowan may have some merit.
It may. And I do, although it's not on the record, and his request to be transferred to a different state, I just want the court, based on in the trial file, I know it's not on the record, he has in the past been transferred out of the state, so I don't know how feasible that would be, because I know that he has been transferred to different state prisons, and they essentially have sent them back.
Well, certainly it would be unusual for the court to enter relief without hearing from a party that was directly affected by the relief, to wit, the Department of Corrections.
Yes,
And here you are not representing the Department
No,
of
I'm not.
Corrections, and you cannot make any representations on their behalf.
Yes.
So we understand that.
Yes. If there's no further questions on anything else, I guess the Commonwealth will rest on its brief.
Thank you, Ms. Howland.
Thank you
We'll take
very
a short
much.
break.
All rise.